All right. Well, for those of you that do not know, today is May the 4th, which is also known as Star Wars Day because May the 4th be with you. I thought it would be fun to look at some Star Wars actors' marriages and divorces that illustrate some important issues in family law. So, the first such example is Ewan McGregor, who, as you can tell from this photo, played Obi-Wan Kenobi in the newer installments of the Star Wars franchise. And Ewan McGregor was married to Eve Mavrakis, and they divorced in 2018 after 22 years of marriage. And in their community assets included residuals and royalties from work that Ewan performed over the course of their marriage. So in that case, the judge ruled that the couple is to split equally all royalties and residuals which are earned by the actor over the course of their marriage. Now, this includes work that was done for which royalties will be paid far out into the future. And I believe everybody's probably heard the term royalties in the past, but what does that really mean? So royalties are payments that are generated from a creative work. An actor, in this case, is entitled to a percentage from each use of the work beyond the original scope. So in this case, video or DVD or streaming services. And these are things that are contractually worked out with the actor and the production company. And typically, an actor will negotiate between 1 to 10% of a wholesale price as future royalties on those types of work. If the actor is confident that the work is going to be successful, they would likely negotiate a higher royalty payment. If not so much, then likely a lower royalty payment for a higher flat fee up front. However, residuals are a little different because they are mandated by the Screen Actors Guild, and they require compensation be paid to performers for use of a motion picture or a television program, also beyond the use covered by the initial compensation. For TV work, that would be once a show starts re-airing or is released to video or DVD, pay television, broadcast TV, basic cable, or any forms of new media. For film work, residuals will begin once the movie appears on DVD, video, basic cable, pay television, also new media. And the difference is that because these are union mandated, these are required payments for actors for this type of work. In addition to residual payments, an actor can also negotiate royalty payments. So what appears to be true from Ewan and Eve's divorce is that he is entitled to both residuals and royalties from the work that he performed for the Star Wars series and for various other things throughout their marriage. But this is potentially a never-ending income stream that they are both equally entitled to. Why I thought this was helpful or interesting anyway is that we are expanding our marketplace and we're expanding different types of employment. So it's quite possible that a spouse or someone you know, a partner, could receive or be entitled to royalties or residuals for different creative works as we expand to things like YouTube or TikTok or things of that nature. How are these people getting paid? What is the compensation structure? And what I have found is that as this is kind of a new frontier, couples often don't inquire about these types of assets pending dissolution actions. But it also applies to other sorts of creative endeavors. So writing a book, musical performances, patents. It can also apply to franchises or mineral rights. And if the work was performed, or let's say the sale of a property that has mineral rights happened during the marriage, those residuals are likely community property. So if you think about different compensation structures for things like, let's say, your partner's in a tech startup, and rather than get paid a significant amount of money as standard employment wages, they're given a percentage of the business or stock options. That's work that is being done while you're together. And if the payment's not going to be, let's say, for 15 years out in the future, you could be entitled, or the community can be entitled, to whatever is generated from that income in the future. So I thought it was interesting to think about, because Ewan's now ex-wife will be entitled to those payments as long as he's receiving them, which could be many, many, many years in the future. The second example that I thought was interesting was Harrison Ford, who plays Han Solo, and the importance of having a prenuptial agreement. So Harrison Ford met Melissa Matheson in 1977, and they married in 1983. At the start of the Star Wars film franchise, Harrison Ford was only paid $1,000 a week and only made a total of $10,000 for his work in Episode 4, which is actually the first Star Wars movie that came out. He was only paid $100,000 for Episode 5, which is actually the second movie that came out. And these are extremely low amounts to be paid for an actor, particularly based on what the films came to be. But fortunately for Mr. Ford, 6 years later, he did become one of Hollywood's highest paid actors and received $7 million for his work in Presumed Innocence. By 1995, he was making $20 million a film. And when they got divorced, they did not have a prenuptial agreement. So when they separated in 2000, it took a little over 3 years for the divorce to be finalized, when they were finally divorced in 2004. And the reason that the divorce took so long is because there was no prenuptial agreement. So in addition to not being in agreement as to how your assets are being distributed, because you have no agreement in place, part of the reason this takes so long is discovery of assets and transparency. And the larger the estate, the longer that's going to take and the more money that's going to cost. So the divorce settlement that was reached after that 3.5-year period was that Harrison Ford paid $85 million to Matheson, in addition to her being awarded a portion of Mr. Ford's future earnings from Indiana Jones and the movie The Fugitive. At the time they got divorced, this was the most expensive divorce in history. So the reason that I thought this was kind of a helpful situation to look at is because a prenuptial agreement can save a significant amount of time and money by avoiding acrimony and costly court battles, because just as nobody gets married thinking that they're going to get divorced, nobody signs a prenuptial agreement thinking it will ever be enforced. But that doesn't negate the need for transparency and discussions to have like this with your partner. And I think in these types of situations, particularly if you do have a partner that has either a non-standard type of employment or works as a performance artist or things of that nature, what does the present and future compensation structure look like for that person? And how do we fairly address that in a prenuptial agreement? So certainly, for performance artists, the hope would be that they become more successful as their career goes on. That could happen, that could not happen, but you might as well discuss the possibility and think about what would be fair 5, 10, 15, 20 years down the road. Additionally, the non-standard employment structure, like the example I mentioned earlier, if you are partners with somebody that works in the tech industry, and instead of getting paid, a significant amount of guaranteed wages, they take a lot less for a big payoff, a high risk, high reward sort of thing at the end. If you're with that person when they're putting in all the hours and doing all that work, and let's say that's 5 years that you've invested as a community, and then, you know, the relationship ends, let's say 10 years later, and then a payment is made, what's going to happen? But these are things that are important to certainly discuss with your partner. Transparency is certainly best prior to marriage and during your marriage. And so discussing these things as you're talking about a prenuptial agreement is a really good way to address that before you've entered into a marital contract. The next one I thought would be interesting to look at is Carrie Fisher, who played Princess Leia. She was in a relationship with Paul Simon, and her situation is pretty interesting. Her and Paul had an on-again, off-again 12-year relationship. They married in 1983, but divorced only a year later in 1984. And in fact, they dated, they separated, they got married, they dated again, they separated, they started dating again. Ultimately, they called it quits in around the late 80s. And after that, Carrie had a child with a subsequent romantic partner named Billy Lord, who, as you can see from the picture below, starred in one of the Star Wars movies with her mom. And after that, Carrie Fisher passed away in December of 2016. So why is this situation interesting? It's because in Washington, we have a statute, which is RCW 11.12.051, subsection 1, that provides if, after making a will, the testator's marriage or domestic partnership is dissolved, invalidated, or terminated, all provisions in the will in favor of or granting any interest or power to the testator's former spouse or former domestic partner are revoked unless the will expressly provides otherwise. Provisions affected by this section must be interpreted, and property affected passes as if the former spouse or former domestic partner failed to survive the testator, having died at the time of the decree of dissolution or declaration of invalidity. So in this case, if it was in Washington state and Carrie had not changed her will after her divorce, her estate would be treated as though Paul predeceased her, not that Paul is simply removed as a beneficiary. And in Washington state, and certainly probably many other jurisdictions, there are a lot of what we call predeceased spouse provisions. So, for example, a predeceased spouse clause would say something like, if husband shall die before wife, then husband's child shall receive his share of community property. I would encourage anybody watching this to review your estate plan and see if you do have any sort of predeceased spouse provisions or things like that. Whether or not you are divorced, getting divorced, or anything, it's important to know if this type of clause is in there. But what this would have meant for Carrie Fisher is that she intended all of her estate to go to her daughter, Billy Lord. So that is what happened. She wanted 100% of her estate to go to Billy. However, if she had this provision in her will and passed away in Washington, or if her estate's jurisdiction was Washington, Paul, and this clause was in there again, Paul's child would receive whatever his share of community property would have been. So Billy doesn't get 100% of the estate, and Paul's child, gets whatever his share of community property would be. So this creates two problems. One being that now my testamentary intent is not met because I wanted my child to have 100% of my estate. So that's a problem. Secondly, what is Paul Simon's share of community property? And that is a difficult question in this type of case because you had a 12-year relationship that was on again, off again, on again, off again, and then a 1-year marriage. So the court can determine that the community, there was partial community before, during, after maybe, but that creates a significant issue in determining what actually that amount would be. So that could necessitate litigation that nobody wants to be involved in, certainly. And again, testamentary intent being extremely important, you want to make sure that whatever you want to happen at the end of your life is actually what is going to happen. So it is extremely important to update your estate plan after a divorce or any other major life event. So if you have a child, if there are any health issues or things of that nature, I mean, it's good to review and do it, every so often anyway, but certainly after huge life events. And for today, I thought I'd end on a little bit of a brighter note, the long-term marriage. So Mark Hamill has been married to the same woman, Mark Hamill, who plays Luke Skywalker, has been married to Mary Lou York for 44 years. It's a cute story. He met Mary Lou at his dentist office because she was his dental hygienist. They met in 1977, which was before the release of the first Star Wars film. Which was released in July of 1978. Then Mark and Mary Lou got married in December of 1978. Over the course of their marriage, they've had 3 children together, the youngest now being 34 years old. So they have what we determined, and it's a legal term of art, a long-term marriage because it's 25 years or longer. And why that matters is because we have a case in Washington that is often referenced called Rockwell, which provides the court guidance with respect to marriages of 25 years or longer. So the court's directive in these types of cases, if there is a dissolution happening, that the court is going to place the parties in roughly equal financial positions for the rest of their lives. The longer the marriage, the more likely the court will be to make a disproportionate distribution of the community property in order to reach that end. So if one spouse is older, semi-retired, dealing with health issues, and the other spouse is employable and has a better disposition, then the court will not abuse discretion in ordering something unequal to ensure that they have equal footing, really, for the rest of their lives. And the important thing to consider the longer that you are married is that you're creating a community, and you are kind of getting rid of whatever separate entity existed. So in Washington State, it's presumed that your community begins at the date of marriage. It could certainly be before, but at the date of marriage, that's when it starts. And everything from that point forward is community. So your income, credit card debt, retirement contributions, unless you have some sort of agreement that states otherwise, that's all going to be community interest, and everything that the partners are doing is for the benefit of the community or to the detriment of the community. So the longer that goes on, the more of a joint endeavor you have and the less separate interest that you have. And in Mark Hamill's case, it would probably be impossible to determine what separate assets or things like that existed in 1977 because the records probably don't exist anymore. And unless there's any agreement that evidences that intent, how would the court know that? So you create this community to the detriment of your separate entities, and that's kind of the point of being married. So it is possible, certainly, that you could have agreements for separate property, but if that is something that you're intent on doing, it's important to know that that would need to be memorialized somewhere, particularly the longer that couples are together, because again, you don't get married thinking that you're going to get divorced. But if there are things that you would like to maintain as separate assets, that's something to consider. So to summarize, it's important to inquire about all types of property with your partner. For transparency's sake, really, whether you're getting married or not, but if you're in a long-term relationship, what is the compensation structure for the partners? Are there non-standard payments for work? Are you entitled to royalties or residuals for anything? Additionally, a prenuptial agreement is going to save a lot of time and a lot of money if you do get divorced. And it actually is a good idea to discuss the things that you have, all your assets and debts, what you're entering into a marriage with. What do you own? What do you want to keep separate? What do you want to keep community? Because that's going to make it better from the start, really. And in the event that you do end up getting divorced, that's going to save a lot of time and money for both of the parties in the future. It's imperative to review and change your estate plan after divorce, or really after any other major life event like the birth of a child. But you definitely want to review those and make sure what is being said is what you want to be done. And then the longer the marriage, the more expansive the community, and the less likely the court is going to be to characterize property as separate. So the hope is that you intend to get married and be together forever, like Mark Hamill and his wife. And that's great. If there's anything at the outset that you want to ensure remains a separate interest, separate debt, separate asset, whatever, deal with that at the start. That is all I have for you today. So I will say, may the 4th be with you. And if you have any questions, emails, feel free to send to annb@beresfordlaw.com or give us a call at 425-776-4100. All right, that'll do it for me today. Thank you for watching.